Welcome to the third hour of American Agenda. I'm Bob Sellers.
And I'm Heather Childers. Thank you for sticking around with us or just joining us. We're now joined by our family of guest co-hosts, former Louisiana Congressman and former Assistant to President Trump, John Fleming, Republican strategist and former chairwoman for the Massachusetts GOP, Jennifer Nassour, and editorial director for the Reactionary Times, Julio Rivera. Welcome to everyone. Great to have you.
Yeah, folks, the Supreme Court taking up a major abortion case next term that could limit Roe v. Wade, could overturn it. The case could dramatically alter decades of rulings on abortion rights, potentially leading to dramatic restrictions on abortion access. Additionally, the court will argue restrictions on carrying concealed handguns in public, which comes as Mr. Biden and his administration push for stricter access to firearms. So how will the court handle all these controversial decisions? Before we bring in our panel to react, let's bring in distinguished university professor at Touro College and author of Saving Free Speech, Thane Rosenbaum. Thane, a lot has happened between now, 1973 and now. Viability of a fetus, we know, is much lower than it was before. I don't know how key that is, but states that want to offer some kind of restriction, will it have more heft now than it did then? And could there be a different outcome in a case that truly challenges Roe v. Wade?
Well, you're right, Bob. It's a good question. The question here is whether the science is more important than this solid 6-3 majority on the Supreme Court with the new 3 Trump appointees. I have a feeling that might have more bearing than even on the science. You're quite right. Roe v. Wade set a standard of viability that allowed for abortions, a woman's right to abortion, for the first trimester, and they picked the period of time, 24 weeks, which was when a fetus at that point would be viable outside the womb. Mississippi has just comes up with a new law that says, why does viability have to be the standard? Why can't it be 15 weeks gestation? As you said, science now are giving us a sense that the fetus might have experienced pain. Maybe that should be the standard, or a fetal heartbeat at the time that a fetus actually has a heartbeat. So that's what makes this case so striking, because it strikes at the heart of Roe v. Wade. This is not really about an access to abortion case. This goes directly to Roe v. Wade's right to abortion, because it speaks to this trimester and this legal standard of 24 weeks. Do you want me to mention the gun case?
Thane, before you go to that, though, explain to folks why that is significant, or the difference that you pointed out there. Why is that significant?
Right. Well, think about it this way, Heather, right? The benchmark was 24 weeks, a woman has an absolute right to an abortion. Social conservatives have all along said, well, wouldn't it be nice if we can't overturn Roe v. Wade, could we at least reduce that time period, right? Make it less. Give a woman only 15 weeks or 8 weeks or 4 weeks. But again, since we've all been operating under the Roe v. Wade standard, we've all been operating under a viability legal standard. And this introduces, if the Supreme Court doesn't have to overrule Roe v. Wade, all it really needs to do is uphold the Mississippi law and say that states can make their own decisions on at what point can a woman no longer exercise the right to choose.
Mm-hmm. So a lot of people on both sides of this issue feel like if Roe v. Wade is overturned, that may not be the right term, but it may be set aside and each state decides what they choose to have as their rules.
Well, right. The Supreme Court could do any number of things. They could overrule Roe v. Wade, or they can set a new standard. They could say, Mississippi is now the new standard. It's not 24 weeks of viability. It's now 15 weeks. And it also could say that states can individually make a decision for themselves based on what their citizens' desires are, or what they consider the morality under the law. There was a concurring opinion that I read where a judge literally said, we're simply not taking in the rights of the fetus to life. You never heard that before, right? That an appellate judge would actually speak directly to the right of the unborn fetus. So yes, there are any number of options, but as I would say, as I said before, even just upholding the 15 weeks in Mississippi is huge.
Yeah,
it doesn't require the sweeping changes that could take place in overruling Roe.
So Thane, before we run out of time, the other case that we're talking about, the concealed carry case.
So very quickly, Heather, the last time the Supreme Court had a Second Amendment case, 2008. That's a long time ago. That was the Heller case. What was Heller? Heller says, well, gun ownership is not limited to just armed militia. Private citizens have the right to keep a gun in their home for self-defense purposes. That's 2008. It's a long time ago. There's been all kinds of gun regulation since. New York has a law that's been on the books for over 100 years that says you have no right to take a concealed weapon outside of your home into the public square. You can own your gun only in your house for self-defensive purposes. So now the question is, if the Supreme Court's already said that there's a private right of ownership for self-defense purposes in the home, why is New York restricting the ability of a law-abiding citizen to also use self-defense by having a concealed weapon in the public square? That's what this case is about. And we know a number of the Supreme Court justices have been disappointed that there has not been a more recent Second Amendment case. I can tell you Justice Alito, Justice Thomas, they feel very strongly about this, and I would not be surprised if they strike down that New York law.
All right. All right, Thane Rosenbaum, thank you very much for breaking everything down for us.
Anytime.
All right. Well, so let's bring in